Hello and welcome to Competology Academy. And today we are going to discuss the recently enacted Jan Vishwas Bill 2022. So it was introduced in the Parliament in 2022. However, it has been enacted and it has been passed by the Parliament in 2023. Thus, it is named as Jan Vishwas Bill 2022, and it is a very important bill with respect to the simplification of the processes, ease of doing business, and other things, because the government have made various claims with respect to this bill. However, we will analyze this bill in totality and whether it is simplification or usurpation of judicial power. So whether this bill attempts to simplify the judicial system or the ease of doing business, or whether it is going to usurp the judicial power, right? So we will analyze here. So first of all, what is Jan Vishwas Bill or the Jan Vishwas Act? Earlier it was bill. After getting passed by the parliament, it has become an act. So now it is an act. It is a law, right? So recently it was enacted into the law by the parliament. It was passed by the parliament and it has become a law, right? Now, mostly it replaced the criminal imprisonment with penalties. So earlier there were many laws, there were many acts under which there was provision of imprisonment. However, this bill replaces the provision of imprisonment with the provision of penalties in place of imprisonment in various bills, in various acts. Some of the examples are here that we will discuss. This has also transferred the power to impose the monetary penalties from the judiciary to the bureaucracy. And that's why we were talking that whether it is the simplification of the procedure or whether it is usurpation of the judicial power of the judiciary. Basically, it is trying to replace the judiciary, and in place of the judiciary, now the adjudication of the violation of some of the laws and acts will be done by the bureaucracy in place of the judiciary. So this is going to be there. And here it has introduced in total of 42 legislations, and some of the examples are here that it has introduced the amendment in Environmental Protection Act of 1986. Here earlier, for the violation of Environmental Protection Act 1986, there were provisions of imprisonment. Now it has been removed, as well as the violator, the culprit, will not be prosecuted in the court of law, but the penalties will be determined by the bureaucrats itself. So basically now the bureaucrats will become the judge of their own cases, right? So here, next is the Air Prevention and Control of Pollution Act 1981. In this also the same kind of amendments have been introduced, right? Now it has replaced the imprisonment as a punishment for certain offences with the penalties of up to 15 lakhs. So earlier there were provisions for the imprisonment. Now there will be no imprisonment, and in place of imprisonment, the person, the violator, the industrialist, or whoever is managing the industry will be penalized for a fine of up to 15 lakh rupees. And this fine is also compoundable for the repented offenders. This fine may be increased also, right? And here they can impose that by the designated bureaucrats, that is to the post of joint secretary. Below this level, the bureaucrats will not be able to impose the fine. The fine can be imposed only by the senior most bureaucrats, Indian Administrative Services officers, or in case of the forest acts, the forest services officers, and they are the designated officer, they are the designated bureaucrats who are eligible to impose, who are having the authority to impose the penalties of on the violators. Here, the amendment has also been introduced in the Indian Forest Act 1927. So earlier, what was happening in the system, if a person was caught of smuggling the forest produce, animals or whatever it is under the Forest Act, then they were being prosecuted in the court of law. If somebody was smuggling some wood or something like that, but now the bureaucrats will inquire into the situation, they will prosecute the person, and in that case, the bureaucrats, the system is itself a party. So they are inquiring their own case, they are ascertaining the damages of their own case, they are prosecutor of their own case, as well as they are going to pronounce the judgment also. So it's a great thing, no? So here the amendments has been introduced in the Indian Forest Act also, and the forest officers have the power to conduct the inquiry, determine the damages done to the forest, and order the offender to pay the fine also. So the whole system revolves around the bureaucrats themselves. No authority of judiciary, no involvement of judiciary, right? So here it has decriminalized or made compoundable the offences across 42 legislations. So compoundable means that the repeated offenders will be facing more higher level of fines, more amount of money that will be imposed as penalties on them. So it has been made compoundable, but they have decriminalized these offenses, so there will be no provision of imprisonment. And if somebody says that I don't have the money, I am not going to give you, then what the government will do? So there may be some circumstances such like that also. So here, what are the government claims regarding this bill? What does the government claims to achieve from this bill? So first of all, the government is saying that it will improve the ease of doing business because there will be no provision of imprisonment. So there will be easy trial, easy and fast trial. So here it will reduce the unwanted litigation in the court of law, like they will do the faisla on the spot like in filmy style, right? So they will just inquire into the issue and they will say that this much of the fine you have to pay, and the whole case will be dissolved, whole case will be adjudicated on the spot, right? Now it will reduce the burden on the judicial system. They say that the judicial system is overburdened. No doubt the judicial system is overburdened, but it doesn't mean that if a person who is a professional driver is driving a vehicle for continuously 15 hours, so to give a relief to him, you will give the driving seat to the conductor of the bus. Will it make any sense? And that is why if the judicial system is overburdened, then you should increase the number of courts, you should increase the number of judges to adjudicate the cases in a more efficient and speedy way, in faster manner, rather than transferring the judicial authority to the executive, that is the bureaucrats, right? Here speedy resolution of the litigation will be there, but there is a proverb that justice hurried is justice buried, as well as you are going to give the responsibility of speedy resolution of the litigation to an inexperienced person in the field of judicial system. So they don't know how the judicial system works, how does they should adjudicate the cases, and you are giving the authority for the speedy resolution of the litigation to the bureaucrats who are good administrators, no doubt, but in the field of law, in the field of judiciary, they don't have any experience, right? And the cost incurred on the judicial litigations will be saved, will be reduced with respect to the government as well as with respect to the industrialists. So they say that both of the parties will save the money, but does it will work well? Now we will discuss that what are the concerns of the administrative luminaries, administrative thinkers, analysts. What does they think? So here, first is already the tax terrorism is in existence in India. Many of the industrialists, small and medium scale industrialists, are being harassed by the tax department, income tax department. Already it is a matter of concern with the Indian industries. Many of the times what happens, they inflate the tax that is being demanded by the income tax department from the industrialists, from the producers or the manufacturers, which they are unable to pay. And definitely it is not that much of tax which the demand is the liability of the industrialist to be paid, and that is why it is called as tax terrorism. They basically harass the industrialists by inflating the tax demands, and later on they manage it. Everybody knows what goes on, right? So here the bureaucracy will have the power to be both the prosecutor and judge of its own case while imposing the penalties. Already we have discussed, there may be arm twisting, there may be the harassment of the industrialists. It may be so that some of the bureaucrats may go on to do the corrupt practices to extract the money from the industrialists. Already every now and then we hear the names of the bureaucrats who are just trying to make money out of their profession. Rather than being a civil servant, they have become the self servant, right? So such kind of things may go on. Not may go on, but definitely go on. Some of the people will be there who will be doing such kind of things, right? As well as it is usurpation of the power of judiciary. Pronouncing the punishment and pronouncing the judgments in any case is the responsibility of the judiciary, not the responsibility of the executives. So basically it is encroachment of the judicial authority. It is encroachment in the field of judiciary and authority of judiciary by the executive, right? And here there will be lack of neutrality. Why there will be lack of neutrality? Because the bureaucrats will be prosecutor and judge of their own case. They will be inquiring the case. So how could they will be neutral? First of all, there may be harassment of the industrialists. Second, if even the bureaucrats are not corrupt, then also to make their portfolio better, to make their profile better, and to show off that they are more prudent in taking the action, more proactive in implementing the laws and the acts, they will go on to do the frivolous things, go on to impose strict measures to extract the penalties and compensation, and to show off that they have enacted the law in letter and spirit, right? So here it goes against the constitutional scheme of separation of power. So the constitution provides that there should be separation of power between the legislature, executive and judiciary, although it is not mentioned explicitly, but it is mentioned under article 50 of the constitution that with the passage of time, with the passage of time, the government should try to achieve the separation of power, right? So it is the responsibility of the government, it is the responsibility of the state to achieve the separation of power. So the fundamentals of the democratic polity should be upheld, the democratic values should be upheld. However, this is being jeopardized, and earlier what had happened with the passage of time, by 1970 many of the state governments had achieved this through enacting various legislations, and they had separated the criminal procedure code authorities from the criminal magistracy of the district magistrate. Before independence, until independence, till independence, the criminal magistracy power as well as the executive authority was with the district collector or the district magistrate itself. But with the passage of time, most of the states have separated the criminal magistracy power from the district magistrate or the district collector, right? But after 1980s, this trend has got reversed. Now the bureaucracy is trying to usurp the judicial power. Bureaucracy has started to usurp the judicial power, and it started in 1980s. Here you can see, just after a decade, in the 1970s it was achieved, and after 1980s it started to get reversed, right? And here it has been done in three ways. First method is the judicial tribunals. Many of the number of the tribunals were created through various legislations or executive orders, right? And here it was to take over various judicial functions. And here what was happening in most of the tribunals, the bureaucrats were also being appointed as the technical members. So the bureaucrats were getting the opportunity to be appointed in the tribunals as the technical members, where they were exercising the judicial power. So basically this was the first method of usurping or encroaching the judicial power, right? Next, the union government created various statutory regulatory bodies. This was a new class of or new system of the encroachment of the judicial authority. Here the regulatory bodies were like SEBI, Competition Commission of India, Securities and Exchange Board of India, thereafter TRI, thereafter IRDA. So such kind of statutory regulatory bodies are being used by the government to regulate certain specific sectors, and these regulatory bodies have the power of civil court. So they can ask for the witnesses, they can ask for the documents, they can examine the witnesses, they can prosecute the culprit, they can impose the fine, they can pass the order, even they can pass or confirm the attachment orders, right? So they can pass the attachment orders for the properties or impose the penalties. So such kind of authorities are there with the regulatory bodies, with the judicial tribunals, with the statutory regulatory bodies. And the third method that is being used by the union government to usurp the power of the judiciary is creating the role of adjudicatory officer. So here some of the bureaucrats are being appointed as the adjudicatory officers in certain specific sectors, in certain specific fields. So here you will find that a number of legislations such as Prevention of Money Laundering Act, IT Act, so such kind of acts are being passed, where the bureaucrats are appointed to adjudicate any issue, to adjudicate and pronounce any judgment. And here it is again the usurpation of power, because the power to pass the order of attachments, to impose the penalties, are the judicial function, not the executive function. They cannot be exercised by the executive or the legislature, right? So here, what are the pressing questions that arises from such kind of bills, from such kind of encroachment of the authority by the executive or the legislature? So first is encroachment of the judicial power. Does it upholds our democratic values? Does it upholds the essence of the constitution? Next, does the imposition of the penalty is a judicial function or an executive function? So here it should be defined that does the imposition of penalty is a judicial function or a executive function. So the definition is needed. Next, whether the penalties are civil or criminal in nature. So whether the penalties can be imposed with the civil order or the executive order, or it should be prosecuted in a criminal sense, and thereafter a judicial system, a judge should pronounce the penalties, should impose the penalties, its quantum, etc. Right? Next, who can guarantee the citizens a fair trial before imposition of any punishment if the bureaucracy is itself a party of that case? Like, the bureaucracy is a part of government, it is a part of state. So the state is itself a party in violation of any legislation. Thereafter, they are inquiring the same case, they are uh, analyzing the damages in same case, they are prosecuting the same case, they are party to the same case, as well as they are the judge of the same case. So who will ensure the fair trial? Does there is neutrality? Will they be neutral? Next, can the government be a prosecutor and a judge of its own case? जज एंड प्रोसिक्यूटर ऑफ इट्स ओन केस, अपने केस के जज खुद ही है. So definitely they will give the judgment in their own favor. So this is a question, this is a issue which should be addressed. So this list of question is the present list of question which should be discussed, right? So here we finish off the discussion of this whole Jan Vishwas will. Let us see how much Vishwas the public should have in this bill. So thank you very much for watching this video. If you have watched the video till the end, then please consider subscribing the channel and press the bell icon to get notified whenever we upload new videos, and do follow us on our Facebook and Instagram handle. Also, you can subscribe to our that Telegram channel. Here you will get the PDF notes of these current affairs issues, and you can also go on to download our app. The description have the link of this app, from where you will get the current affairs magazine in both the languages, Hindi and English, various practice questions and other things. And the same resources are available on our website also. So thank you very much, and get back in the next analysis session at the same time in the evening at the same place, that is the Competology IS Academy. Thank you very much and have a nice day.